Welcome to Bond University on iTunes U.
So I'm Claudia Geiringer from the Victorian University of Wellington School of Law, and I was sitting at my computer about 6 months ago pounding away at an urgent advice for a client when an email arrived from Patrick, with whom I should clarify for the purposes of the anecdote I had never previously met. I scanned through the email, clocked the words Gold Coast and invitation, an image of palm-fringed beaches wafted through my mind, and without further ado I forwarded the email to my partner with the following commentary. Good invite! Exclamation mark. 5 minutes later I received another email from Patrick. Oh, is that a yes? Well, Patrick, I guess that was a yes. Thank you for the gracious invitation to participate in this seminar series, and thank you also for not retracting the invitation on receipt of that somewhat unsophisticated response. And look, it's great to be here in the gun capital of Australia, not just because of the palm-fringed beaches, but also because I'm a Bill of Rights junkie. I'm fascinated by the permutations and implications of the statutory Bill of Rights model that's taking hold throughout the Commonwealth, and I'm always delighted to have an opportunity to engage with others with an interest in these issues, as is, I hope, the case with this audience. I don't want to lay claim to any depth of knowledge about the Queensland conversation over human rights protection, but in preparing for today's remarks, I did glance, amongst other things, at the report of the Legal, Constitutional and Administrative Review Committee in 1998, rejecting the Electoral Commission's proposal that Queensland should adopt a Bill of Rights. And as this audience will know much better than me, the committee's detailed report focuses primarily on concerns that would pertain to the introduction of an entrenched Supreme Law Charter, but intersperses that discussion with somewhat cursory and, to my mind, largely unsupported remarks about the parallel dangers that would accompany a statutory Bill of Rights. For example, having articulated the concern about the significant transfer of legislative power to the judiciary that's occasioned by a Supreme Law Charter, the committee noted breezily, New Zealand's experience with a statutory Bill of Rights also indicates that a Bill of Rights need not be constitutional in form to effect a significant transfer of power. The New Zealand courts have embraced that country's Bill of Rights so as to give it almost quasi-constitutional status. Although no authority is cited for this proposition, it certainly has been said by New Zealand judges and commentators that the New Zealand Bill of Rights has a quasi-constitutional or even constitutional status. But what does that mean? In New Zealand we have no higher law written constitution, and so that language of constitution, constitutional, quasi-constitutional is used in a very different way from on this side of the ditch. We consider a number of key public law statutes to be constitutional, not because they transfer legislative power to the judiciary, but because they set out the basic structure of government, allocate public power, or regulate the relationship between citizens and state at a broad level. We would apply the same descriptor to certain common law rules, as well as to certain unwritten conventions and principles. So the New Zealand Bill of Rights is quasi-constitutional in the same way, for example, that many judges and commentators in New Zealand would now describe important common law presumptions of interpretation as constitutional, because they reflect the court's historic constitutional role, albeit with within the strictures of our system of legislative supremacy, in protecting individual liberties. Now, undoubtedly there are sceptics who consider that the Bill of Rights is more injurious than beneficial to the public good, and I know you've heard from at least one of those in this seminar series. And they raise concerns, for example, about the open-endedness of many of the concepts contained in the Bill of Rights and about the additional litigation burden that it undoubtedly generates. Those are reasonable conversations to have, even if I don't necessarily share the concern. But to suggest, at least with reference to the New Zealand context, that the introduction of a statutory Bill of Rights led to the transfer of legislative power to the judiciary is to make a category error. The Bill of Rights reinforces, rather than supplements, traditional spheres of judicial power to protect individual liberties against the executive and to interpret legislation in light of fundamental values. Now, a related concern expressed by the Legal, Constitutional and Administrative Review Committee in 1998 was the difficulty in predicting what the courts in any particular jurisdiction might choose to make of a statutory Bill of Rights. The committee contrasted the experience in Canada with the Canadian Bill of Rights of 1960 with the early experience in New Zealand under the New Zealand Bill of Rights Act. The former had been something of a dead letter, and the latter, so the committee said, embraced by the New Zealand courts as an integral and evolving part of New Zealand law. And the committee drew the somewhat glass half full inference from this, that the attitude and approach of the judiciary is an unknown variable that reinforces the unpredictability and therefore undesirability of enacting a Bill of Rights. Undoubtedly, as with any law that asks the judiciary to interpret and apply broad powers, there is a degree of uncertainty when enacting a Bill of Rights as to the effect that it will have. After all, the whole point of enacting a Bill of Rights is to create broad standards against which executive, if not legislative, power can be measured on a case-by-case basis. And it's a matter of record that the somewhat spirited approach taken by the New Zealand Court of Appeal in the early years of the Bill of Rights jurisprudence took many people by surprise. It was unexpected, both because of the Canadian precedent, but also because the debate in New Zealand at that time had focused almost entirely on the pros and cons of a Supreme Law Charter, and no one had paid much attention at all to the intriguing possibilities presented by a watered-down statutory version. In the last 2 decades, though, the international landscape has fundamentally changed. And as you all will be aware, the New Zealand experiment has been repeated in the United Kingdom, the ACT and Victoria, and there's now a wealth of comparative experience on the operation of these dialogue-based statutory models. The overarching theme of my address today is that a nuanced appreciation of that comparative experience and attention to it in the drafting process can significantly reduce the degree of uncertainty and unpredictability inherent in the enactment of any new statutory human rights charter, a Queensland charter, for example. I certainly don't want to go so far as to suggest that uncertainty can be eliminated. Each human rights charter is sui generis as it's embedded in the unique constitutional framework and culture of the particular jurisdiction. And inevitably, judicial personality does play a role. But the proposition that I want to explore today is that many of the variations in the ways these statutory charters have played out in practice in different jurisdictions were, in fact, entirely predictable. That's because they weren't arbitrary or idiosyncratic, but rooted either in different choices that were made in respect of the design of the particular instrument or in identifiable aspects of the legal and constitutional culture in which the instruments were embedded. And I'm going to explore that proposition today by comparing and contrasting the early experience with a statutory human rights charter in the 2 jurisdictions that I have significant personal experience of, New Zealand and Victoria. The broad outline of those 2 instruments is of course similar. Each sets out a core list of civil and political rights and seeks to incentivise the protection of those rights through the political processes. Each requires public bodies to act compatibly with these rights, at least in the absence of a clear legislative direction to the contrary. Each uses statutory construction as a key technique for promoting legislative compliance with human rights norms, but stops short of allowing judges to strike down or disapply legislation when this technique fails them. But there are numerous and sometimes significant differences in the operation of the 2 instruments. Some of these are inherent in the texts, and others are less readily accessible as they flow from the broader legal, constitutional and even social context in which the 2 instruments operate. In exploring those differences today, my starting point is not going to be the text, but broader trends in relation to the practical experience of the Charter and the New Zealand Bill of Rights Act before the courts. It would be easy to write a book on this subject, so I'm going to have to be highly selective. In the limited time available to me, I want to concentrate on 2 points of difference between the 2 jurisdictions. First of all, the seemingly modest number of criminal procedure challenges in Victoria during the first few years of the Charter as compared with New Zealand. And then secondly, the flip side of this, the adventurous start that the Victorian Bar has got off to in exploring the impact of civil rights outside of the criminal procedure context as compared with New Zealand. And I'm then going to work backwards from those trends to how one might account for them, whether from the text or elsewhere. One comparative question I'm not going to try to tackle today is the legislative scrutiny aspect of the two regimes. There are a number of reasons for this, the main one being that it's just such a huge topic on its own, but also as a former employee of both the Crown Law Office in New Zealand and the Victorian Government Solicitor's Office, it's a little difficult for me to speak with absolute openness about my observations of what happens in practice in those processes. So I'm going to stick more to the role of those two instruments before the courts. So, the impact of the Bill of Rights and the Charter in criminal procedure cases. Well, one of the derogatory epithets that has been applied on occasion to both instruments is that they are rogues' charters, by which I suppose is meant that they work primarily to enhance the interests of criminal defendants. And in New Zealand, that epithet has a degree of resonance, at least to this extent, that the enactment of the Bill of Rights produced a flourish of criminal procedure challenges before the courts, that many of them were successful, that they generated a wave of transformative jurisprudence from New Zealand's appellate courts, and that for a time at least, the ability of criminal suspects to challenge investigatory police conduct was significantly enhanced, for better or for worse, depending on your perspective. It was this feature of the New Zealand experience that led the Legal, Constitutional and Administrative Review Committee here to make the comments that they made about the early New Zealand experience. Now, to date, this just has not been the experience in Victoria. So far, the Victorian Charter has generated a comparatively modest handful of criminal procedure cases, and few of these have had a transformative effect on the rights of criminal defendants or the remedies available to them. In Victoria, the mud just simply doesn't stick. So why might that be so? The two instruments contain a very similar list of criminal procedure protections. Indeed, if anything, the list in the Victorian Charter is somewhat more expansive than in the New Zealand Bill of Rights. So what accounts for the difference? Well, part of the answer, I suspect, lies in the technical formalities to raising a charter argument, which are largely absent in New Zealand. So the requirement in Victoria to formally notify both the Attorney General and the Equal Opportunity Human Rights Commission before a charter point is taken may well discourage criminal defence counsel, who we all know really operate on the seat of their pants and don't have the opportunity to focus on legal argument until the last minute. And in New Zealand, the position is much more flexible, that there are no more procedural formalities to raising a Bill of Rights point than there are to raising any other legal point based on any source of law. In my view, though, the primary factor driving the different experiences in the two jurisdictions in this regard is the remedial frameworks that have operated at the relevant times. The reality is that in New Zealand, as in Victoria, by far the majority of criminal procedure protections contained in the New Zealand Bill of Rights add little of substance to long-standing protections found in statute or common law. But in New Zealand, in the first few years of the Bill of Rights, the main incentive for criminal counsel to take Bill of Rights points lay in the approach taken by the Court of Appeal to the establishment of remedies, and in particular in this context, the remedy of exclusion of evidence. At common law in New Zealand, the presumption was that, well, still is, that evidence obtained unlawfully would be admitted subject to a very weak discretion to exclude on the grounds of unfairness. Under the Bill of Rights, the Court of Appeal developed what became known as the prima facie exclusion rule, a rule of presumptive exclusion following breach of the Bill of Rights, subject to very tightly constrained exceptions. And in practice, this so-called prima facie exclusion rule operated as something close to a rule of automatic exclusion. For that reason, the incentives for criminal counsel to establish Bill of Rights breaches rather than to rely on common law protections were considerable. Now, before returning to Victoria, it's worth noting that this prima facie exclusion rule has now been abandoned in New Zealand and replaced with a general balancing test, a matter for congratulation or commiseration, depending on your perspective, but one that has substantially lessened the significance of the Bill of Rights in criminal litigation. In Victoria, in comparison, the remedies available for breach of the Charter have been tightly constrained from the outset. Section 39 limits relief to situations in which, quite apart from the Charter itself, a remedy or relief would be available if the decision was made unlawfully. Prior to the entrance into force in Victoria of the Uniform Evidence Act at the start of 2010, it wasn't entirely clear what that provision might mean for the exclusion of evidence, but Section 138 of the Evidence Act is pretty explicit. It applies to all evidence obtained improperly or unlawfully, which includes, but is obviously not limited to, breach of the Charter. And it dictates a balancing exercise that starts with a presumption in favour of exclusion, but allows for admission if the desirability of admitting the evidence outweighs the undesirability. There is doubtless some potential for some case law to develop on the particular significance of the Charter breach to a decision under Section 138, whether or not to exclude, but there's little chance within this framework of the courts developing a strong rule of near automatic exclusion like the one that characterised the early New Zealand case law. So for this reason, the Victorian Charter just doesn't, to my mind, contain within it the transformative potential in the criminal procedure area that the New Zealand Bill of Rights had in its early years. The rights contained within it are by and large already protected by common law and statute, and the remedies available to courts for breach of one of those rights are by and large no different from the remedies available to respond to other forms of unlawful conduct. Now, a similar line of analysis has led at least one commentator to suggest that the Victorian Charter is largely redundant, and I want to explicitly disassociate myself from that view. Even in the criminal procedure context, the enactment of the Charter is significant for a number of reasons. One is that it recalibrates the relationship between common law criminal procedure protections and statutory abrogation by requiring explicit justification of the reasons for abrogation during the legislative process, as well as potentially before the Supreme Court on an application for a non-binding declaration of inconsistent interpretation. And secondly, it undoubtedly has an important role in reinforcing and galvanising existing common law and statutory protections. So in some cases it might be the factor that pushes judges across the line in deciding to take an expansive approach to those protections or to utilise existing remedies to give relief in a particular case. And the Charter might have that role in some cases without it even being explicitly acknowledged. So sometimes Charter cases actually pose as common law cases. But third, despite the similarities in coverage that I've talked about between common law statutory protections and Charter protections, there are inevitably some gaps in protection that will be exposed and hopefully corrected as Charter jurisprudence develops. One example relates to the impact of the right to privacy in Section 13 of the Victorian Charter on the use of modern surveillance technologies. In a recent case in the Victorian County Court, the judge relied on Section 13 to adopt a novel interpretation of the Victorian Surveillance Devices Act that rendered illegal the actions of a police officer in assisting a complainant to record a telephone conversation with an alleged offender from a telephone at the police station. Now, for those familiar with the comparative jurisprudence, there was nothing particularly startling or unexpected in this development. The comparative case law clearly establishes that the right to privacy, and indeed even the more narrowly worded right to be protected against unreasonable search and seizure that appears in the New Zealand instrument, goes significantly further than the common law in protecting against interferences with privacy that result from the utilisation of electronic technologies. Nevertheless, this is certainly an area in which the Charter has the potential for transformative impacts on criminal procedure. Other rights that might have similar potential might include the right of children to special protection and the right of prisoners to humane treatment. But even in regard to these rights, the transformative potential of the Victorian Charter is constrained by the conservative remedial framework in which the rights are embedded. So, for example, in the County Court decision that I just mentioned, in which the judge held that telephone surveillance had been unlawful, he nevertheless exercised his discretion under Section 138 of the Evidence Act to admit the evidence. So while the police were required to adjust their practices for the future, essentially by instigating a warrant requirement, they didn't lose the vital evidence obtained in good faith from the illegal recording. So far I've given two essentially negative explanations for why early Victorian Charter jurisprudence hasn't been preoccupied with criminal justice issues. There have been procedural impediments that don't exist in New Zealand, and the remedial jurisdiction is not as expansive as the New Zealand one was. But I now want to turn to the second of my topics, the performance of the Charter in the area of civil law claims. And as a segue between the two topics, I want to suggest that perhaps another reason why the Victorian Bar hasn't run riot with the criminal procedure protections in the Charter is because they've actually been kept busy exploring the potential of the Charter outside the criminal procedure arena. And here again, the contrast with New Zealand is striking. As we approach the 21st birthday of the New Zealand Bill of Rights this month, I think most commentators would agree that its potential outside the area of criminal procedure has barely begun to be realised. There are admittedly a handful of significant cases on freedom of expression, many though coming out of the context of criminal law challenges. There's almost nothing of significance on freedom of religion, movement or assembly, almost nothing on cultural rights, and a Bill of Rights discrimination jurisprudence has finally begun to take off just in the last couple of years. Although it's early days in Victoria, the Charter's got off to a far more adventurous start. To give some examples, there have been cases already concerning the right of a female prisoner to undergo IVF treatment, the freedom of movement of a psychiatrically ill patient under a community treatment order, a case establishing a positive right of access to government documents as inherent in the right to freedom of expression, and a case restricting the circumstances in which a mentally ill patient could be deprived of control over his property through the appointment of an administrator. And those are just some examples. So how might we account for this difference? Well, one possibility worth considering is that it's driven in part by remedies, just as was the different experience of the two jurisdictions in relation to criminal procedure challenges. And certainly the administrative law remedies are better defined in the Victorian Charter than in the New Zealand Bill of Rights. Properly understood, it's by no means clear that they go all that much further, but the proper understanding bit has been a bit of a challenge for New Zealand courts, and the case law about the role of the Bill of Rights in the administrative law context remains somewhat confused and contradictory. On the other hand, New Zealand has the civil remedy of damages, which is unavailable in Victoria, but that remedy has not opened the floodgates that some predicted, and in fact has had explicit constraints placed around it by both statute and case law. For example, recent case law suggests that not all rights are likely to attract the protection of a damages award, and that it has most relevance actually in the context of criminal procedure rights. An important remedial difference between the two instruments is the existence of an express power in the Victorian Charter for the Supreme Court to make declarations of inconsistent interpretation, as they're called. And I may make some extended remarks on that topic in the written paper, as I do think the inclusion of that power in the Victorian instrument has already resulted in fundamental differences emerging between the two jurisdictions in the way that judges conceptualise their role in charter cases. But for want of time today, and as declarations of inconsistent interpretation have so far only really been sought in civil cases, and as far as I'm aware none have been made outside the criminal context, I'm going to gloss over that issue today. But I want to move away from the question of remedies and focus my remarks on a rather different textual distinction between the two instruments, because a remarkable feature of the early Victorian judicial challenges in the civil law area, at least from my perspective, is the extent to which they have focused on rights that are in fact entirely absent from the New Zealand Bill of Rights. And I'm thinking in particular about the right in Section 13 of the Victorian Charter not to be arbitrarily deprived of privacy, family, home or correspondence, and also to a lesser extent of the rights to protection of children and families in Section 17, and of the broad right to a fair hearing in civil proceedings in Section 24. Well, it's perhaps an obvious point, but one worth restating, that the rights that are included in a Human Rights Charter are by no means preordained, and the choices that are made as to what to include will have a fundamental impact on the jurisprudence that develops. And in that light, it's instructive to reflect on the omissions in the New Zealand Bill of Rights and the reasons for those omissions, which were by no means accidental. And the primary reason for the omissions that I've just mentioned was that the drafters of the New Zealand Bill of Rights were hugely influenced by the process school of United States constitutional thinking led by theorists such as John Hart Ely. And that school of thinking is an attempt to reconcile judicial protection of human rights norms with the democratic legitimacy concerns that may be thought to arise when courts are given the power to review governmental and especially legislative policy. The theory suggests that these legitimacy concerns can be avoided if the court's role is limited to policing process rights. And these can be grouped, according to this theory, into two broad classes: rights arising in the criminal justice process and democracy reinforcing rights, such as the freedoms of expression, assembly and association. Freedom of discrimination also slips through the net because it's aimed at the protection of insular minorities whose interests are not well protected through a majoritarian democratic system. But on this theory, judicial review becomes illegitimate when it strays beyond these process rights to police the substantive content of government social policy. The drafters of the New Zealand Bill of Rights were heavily influenced by this theory, and it explains many of the absences in the New Zealand Bill of Rights Act. In short, the drafters tried to omit any broad, malleable language that might open the way for judges to inject their own values into questions of substantive social policy, as had arguably been done by the United States Supreme Court during the 1930s to block Roosevelt's New Deal, and again arguably by the court in the 1970s in Roe v. Wade, the leading US decision on the constitutionality of abortion laws. So generalised concepts such as liberty, security, and even equality are entirely absent from the New Zealand Bill of Rights. Privacy, a notoriously malleable concept, is reflected only in the more narrowly worded protection against unreasonable search and seizure. Property is gone, as are the various rights in the International Covenant on Civil and Political Rights concerning the protection of children and families. Well, with this in mind, it's fascinating to a Kiwi how much of the early Victorian Charter jurisprudence has concerned these ghosts of the New Zealand Bill of Rights Act, and most particularly has concerned the right to be free from arbitrary interferences with privacy, family, home or correspondence. This right provided the undoubted impetus for the Castles litigation concerning the right of a prisoner to access IVF, although admittedly it was not ultimately relied on by the judge in reaching her decision. It's been at the centre of numerous public housing challenges, including one that I believe is currently before the Court of Appeal. It's been used, albeit unsuccessfully, to attempt to challenge a civil forfeiture order in the proceeds of crime context, as well as the application of a sex offenders registration scheme, and it's been used successfully to challenge the appointment of an administrator to manage the property of a person with a psychiatric illness. Other, even broader facets of that right have had to be tackled in the statement of compatibility context in the legislative process, such as the possibility that the right may in some circumstances prevent a person from being denied access to a livelihood. Few of any of these challenges would be available on the New Zealand instrument. Now, I'm not inviting you to take from this discussion that the Victorian approach is necessarily better than the New Zealand one, or indeed the inverse. In my view, something can be said for each approach. In favour of the inclusion of a privacy right, there is of course the bare fact that it's one of the international obligations that both New Zealand and Australia have committed themselves to discharge, and the profusion of early charter cases may tell us something about how important Victorian human rights groups regard this right. Particularly in the housing context, it's provided a vehicle to advance claims of protection for the most disadvantaged in the community. There's also the point that the substantive rights in the New Zealand instrument were drafted when a fully entrenched supreme law Bill of Rights was in mind. So when that project was abandoned and the instrument was transformed into an ordinary statute, the decisions as to which rights to include weren't revisited. And as I suggested in my introduction, it's far less clear that the democratic legitimacy concerns held by the drafters have as much resonance in the context of a statutory instrument that reserves to Parliament the right to legislate as it wishes. Nevertheless, in reflecting on the omissions in the New Zealand instrument, it's interesting to return to the 1998 report of the Legal, Constitutional and Administrative Review Committee of the Queensland Parliament, in 1998, who shared the concerns held by the drafters of the New Zealand instrument that the judiciary are not well equipped to resolve far-reaching social and economic policy questions. The point, though, is that the drafters of the New Zealand instrument addressed that concern through the omission of certain rights, and that the New Zealand experience to date indicates that, for better or worse, that drafting technique, perhaps combined with the ordinary law status of the instrument, has actually been remarkably successful in achieving that aim. The right to privacy is undoubtedly extremely broad and its contours somewhat uncertain and unpredictable. So in Patrick's case, Justice Bell of the Victorian Supreme Court recently defined it as follows. The purpose of the right to privacy is to protect people from unjustified interference with their personal and social individuality and identity. It protects the individual's interests in the freedom of their personal and social sphere in the broad sense. This encompasses their right to individual identity, including sexual identity and personal development, to establish and develop meaningful social relations, and to physical and psychological integrity, including personal security and mental stability. It's very broad. The Victorian experience to date indicates that whereas some justices, such as Justice Bell, have embraced it, others have clearly had considerable apprehensions about the tasks that they're being asked to perform under the guise of Section 13 and about the value judgments that are expected of them. And as a result, significant differences in interpretation are opening up in the Supreme Court around this right, which will need to be resolved in due course. And I must admit that I do have some sympathy for those judicial anxieties, because I experience similar unease about the kind of judgments sometimes being required of me when attempting to advise governments in the statement of compatibility context as to legislative compliance with Section 13 and other broadly phrased rights. For some, on the other hand, the breadth of this right and the opportunities that it gives for judicial protection of personal autonomy are to be celebrated. The point, though, for these purposes is simply that if broadly phrased rights of this kind cause anxiety and increase uncertainty, the New Zealand comparator provides a straightforward solution: omit them. Well, so far in looking for explanations for the more adventurous start the Victorian Bar has made in exploring the implications of the Charter outside the criminal law context, I've focused on differences in the texts of the two instruments, whether in relation to the substantive rights that have been included or the remedies that are available. But I want to turn to consider some features of the broader legal context in which the two instruments are embedded, and I want to focus on two aspects of this. First, I want to comment briefly on the significance of the Victorian Civil and Administrative Tribunal as an accessible, low-key forum in which a broad array of civil charter cases can be, and indeed have been, brought. VCAT has been the first instance forum for a broad array of significant charter challenges, including a series of significant cases relating to public housing. And there's no New Zealand equivalent to VCAT, but I understand there is a Queensland equivalent. I've got no doubt that the existence of that forum has opened up the way for challenges that would not otherwise have been brought. The second aspect of the broader legal culture that I want to comment on is a little harder to pin down, and it concerns the role of civil society in supporting the Victorian Charter process, because a quite pronounced difference between the two jurisdictions, at least in my view, concerns the higher level of engagement from a broader range of agencies in Victoria with charter litigation. So in Victoria, charter dialogue before the courts has already incorporated a number of participants. The particular Crown agencies whose decisions are being challenged, the Attorney General and the Equal Opportunity and Human Rights Commission, both who have a formal right to intervene in any case they choose, or any charter case, the Director of Public Prosecutions in a criminal case, the Victorian Government Solicitor's Office, the Solicitor General and the Bar, and importantly, a range of pro bono agencies that have either assisted claimants to bring claims or appeared as a marquee. In New Zealand, by far the majority of Bill of Rights cases to come before the courts have had two parties, the party bringing the challenge and the public body whose actions are being challenged. And this is the case not just in the rats and mice litigation, but in most of the key test cases that have been brought under the Bill of Rights. The Attorney-General has intervened only rarely, and the Human Rights Commission even less so. And there is also an absence of real possibilities, real avenues for prospective claimants to seek pro bono assistance. Now, I don't want to suggest that the multiplicity of agencies involved in the child litigation process in Victoria is an unmitigated good. As far as the representation of the government side of the equation is concerned, on the whole, I actually prefer New Zealand's rather less fragmented system. In New Zealand, there's no strict separation between solicitors and barristers, and the combination of this factor, together with the Crown Law Office's rather stronger monopoly over Crown litigation and its supervisory role in relation to the prosecution service, have meant that the Crown Law Office has been able to exercise a degree of control over the conduct of Bill of Rights litigation that's absent in Victoria, and on the whole, I think that that's been a good thing. But when it comes to the voices on the other side of the equation, the Victorian comparator exposes serious deficiencies in this aspect of New Zealand's legal culture. And I've no doubt that the lack of civil society engagement in New Zealand with the Bill of Rights is a significant part of the explanation for the absence of a thriving Bill of Rights jurisprudence outside of the criminal procedure area. Now, I don't have time to explore in any great depth the reasons for this substantial cultural difference, even if I could manage to pin them all down, but I've got a few ideas. The formal intervention role given to the Attorney-General and the Equal Opportunity Human Rights Commission under the Charter presumably has something to do with it, as does the existence of a panel system for government legal contracts, which requires private law firms to commit to a percentage of pro bono work. I don't know if that's something you have in Queensland as well. A suggestion has been made to me that, ironically, part of the answer may lie in a historically more generous civil legal aid system in New Zealand, which has meant that a pro bono legal culture has been slower to develop. But I wonder if there's a more deeply embedded aspect of constitutional culture at play. In New Zealand, in the absence of a written constitution, we've never really seen the courts as much of a place to advance social policy agendas. And that's perhaps the reason that civil society has been slow to adjust to the possibility that a Bill of Rights, even quite a weak one, might be able to offer. Well, drawing the threads together, what lessons are we to take from this comparison? First, there's not one statutory human rights charter model, but rather a series of variations on a theme, each of which combines the different elements in their own unique way. There are shades of dialogue, as the title that I've given to this talk suggests. This means that there are a series of instrumental design choices to be made that have the potential to impact in significant ways on the performance of a charter, whether before the courts or elsewhere. And the decisions that are made as to the rights to include and their remedies to make available are of course important, but other choices such as the procedural formalities that attend a charter claim and the parties that are to be represented before the courts can also have a highly significant impact. Secondly, in making these design choices, there is now a considerable body of knowledge to draw on as to the experience in other jurisdictions that can significantly lessen the uncertainty and unpredictability inherent in enacting a Charter of Rights. Again, it would be naive to suggest that all uncertainty can be eliminated. The Legal, Constitutional and Administrative Review Committee were undoubtedly correct up to a point when they gloomily forecast that if Queensland were to adopt a Bill of Rights, it would, heaven forbid, take on a life of its own. But much uncertainty can be lessened or eliminated by good drafting and by a nuanced appreciation of the lessons to be drawn from other jurisdictions. An object lesson in this regard can be drawn from the debate in Victoria over the strength of the command in section 32 of the Charter to interpret statutes compatibly with human rights where possible. Interpretive directions of this kind are of course a standard feature of this statutory human rights model, but by the time the Victorian Charter was being drafted, an apparent gulf was beginning to open up between New Zealand and the United Kingdom as to the scope and effect of these directions. In the United Kingdom, a stronger approach was emerging that it enabled the courts to use the equivalent direction in Section 3 of the UK Human Rights Act to depart from both the language in which the provision being interpreted was cast and indeed the intention reasonably to be attributed to Parliament in using the language in question. In New Zealand, a more restrained approach was emerging that drew inspiration from the common law presumption of legislative consistency with fundamental rights, but that regarded the text and purpose of the statutory provision as ultimate constraints on the limits of permissible interpretation. Well, the drafters of the Victorian Charter could easily have clarified which of these two approaches should be adopted in Victoria through the choice of statutory language and through accompanying explanation, for example, in the Consultation Committee report and the explanatory memorandum. Instead, the official documents actually plant the seeds of ambiguity. For example, the Constitution Committee report notes reassuringly that Section 32 will reinforce a purposive approach to statutory interpretation, but then, literally in the same breath, gives a nod to the United Kingdom case of Gaidan and Gaidan Mendoza, a case generally seen to reflect the high watermark of the strong UK approach and to be inconsistent with a purposive approach to interpretation as that phrase is traditionally understood. So either the Consultation Committee did not properly understand the comparative literature, or it was, as I suspect, being deliberately abstruse. Whatever the reason, this ambivalence in the drafting history has certainly given rise to considerable uncertainty in the early years of Charter jurisprudence. The Chief Justice was quick to signal her adherence to the strong approach, and some other judges followed, but in the Queen and Momcilovic, the Court of Appeal took a different view, and the matter's now, of course, before the High Court. The short point is that this area of considerable controversy and uncertainty could have fairly easily been avoided. So to recap, uncertainty is an inevitable feature of any statutory regime that asks a court or courts to interpret and apply broad powers, but the likelihood of there being nasty surprises can be significantly minimised by careful drafting in light of a nuanced appreciation of comparative experience. The related point is that some rights and some remedies give rise to more uncertainty than others, the right to privacy, for example. Even within the general species of statutory human rights charters, there's room for opposing philosophical visions as to what the proper role of the courts is vis-à-vis, for example, broad social policy questions. And the answers to these philosophical questions do not need to be thrown to the courts themselves. They can be answered to a large extent through the drafting choices that are made. This means that the choice posed in 1998 by the Legal and Constitutional Administrative Review Committee between no Bill of Rights, a Supreme Bill of Rights, or a statutory Bill of Rights has become a false dichotomy. The choices that are now available to law reformers for how to reconcile democratic imperatives with the judicial protection of human rights are far more varied and sophisticated than they have ever been. The final conclusion to be drawn from today's comparison is that in addition to the text of the instrument, wider cultural and contextual factors are undoubtedly important to how a human rights charter operates in practice. It may be a little harder to pinpoint these and therefore to predict with confidence their impact on the practical operation of a charter. Nevertheless, comparative analysis yields lessons here too. One is that the extent to which civil charter challenges are brought is likely to be in proportion to the affordability and accessibility of civil litigation more generally within the particular legal system, whether as a result of accessible first instance fora, such as a civil and administrative tribunal with broad jurisdiction, a robust civil legal aid system, a strong pro bono culture within the legal profession, or the existence of vital civil society organisations supporting a tradition of public interest litigation. And on that note, I'm going to make room for questions and discussion.
For more information, visit bond.edu.au/iTunesU.